Thank you so much. Right, well, good afternoon, ladies and gentlemen, and thank you very much indeed for the invitation. It's a subject which I enjoyed discussing in general terms because I do have two projects which I look after. One is in Barnsley, and that's the Barnsley Business Innovation Centre. It's called the Business Village nowadays. And every second Tuesday, when there's not a pandemic, between 4 o'clock and 6, I run a pro bono clinic. And you don't have to be in Barnsley, you can be anywhere in the world for that. But obviously, if we haven't got a pandemic and I'm doing 4 slots for 30 minutes each, then you'd have to get to Barnsley. Not too difficult from Manchester. And the other project which I look after is the Menai Science Park. And I think this has got a lot in common with your enterprise here. First of all, it's a spin-off of Bangor University. They have two big projects. One is for the Science Park, which is just on the Anglesey side of the Menai Straits. Various times there'll be pictures of this because I drafted this. I gave this presentation a year ago with them, though I have tailored it a little bit for you. And the other thing is they've got this Arts and Innovation Centre, and both our chair and I visited that about 18 months ago, or just before the pandemic, and to see a performance of a visiting dance company. And I was very impressed indeed with the theatre. They have a cinema, but they also have a fab lab as well. And there are lots of social enterprises, not all that different from you, who have got projects which are not all that different from yours. Now, the view behind the title slide is of the Patent Office, the UK Intellectual Property Office, which is responsible for registering patents, trademarks and designs. And in a minute, we'll be talking about why that can be important. But I'm going to just talk about the agenda, which I think I want to cover today. I did mention that I wrote this presentation originally for the Menai Science Park. This beach is not very far from them. It's a place called Thrive Craig or Blackrock Sands, a lovely place where you can drive your car for £5. I'm going to be talking, first of all, what is intellectual property, why it's important, and it's important for universities, private individuals, as well as Microsoft and Siemens and vast companies, how to protect investment in different types of intellectual assets. Now, there's a distinction between intellectual property and intellectual assets, which I'll deal with first, but generally speaking, the invention as an asset, the patent, which protects investment in the asset, is the property. The J.K. Rowling book is the asset, her copyright is the property. We'll be talking about that later. Some of these rights you need to register at the Intellectual Property Office or other intellectual property offices around the world. Unlike personal property, a £5 note, if anybody steals it from you, I'm afraid that with a few exceptions, you have to go out and bring proceedings in the courts, and that can be expensive. And finally, I've got a section where to get more information, advice and assistance. And since the patent attorney, who I think has already been advising you, is a partner of a patent attorney who is on this list, everything which I've got down here, even though it's designed for North West Wales, would be appropriate for you as well. So without more ado, let's get on. Oh, and by the way, this view is the inside of this science park. It's really quite beautiful. You can see the mountain ranges of Gwynedd just through the glass. This is their atrium. It's where they have all their bright ideas. It only opened in 2018 on St. David's Day, and they're already doing tremendous work. And one of the things which I do, as I say, is give talks like this, and I do clinics, and I do various other bits and pieces. I also do occasionally paid work for different businesses there, but that's after I've given them, as I shall be giving you, a lot of general information. Now, intellectual property is a collective term for a bundle of laws, that's to say patent law, trademark law, copyright law, that protect investment in intellectual assets. And there are 4 of those: brands, that's to say the identity of a business. It can be its trademark, but it usually means a bit more than that. The appearance of its goods. You can have service design, but basically design is concerned with appearance. Can be technical and it can be aesthetic. We'll be going through that in a second. Technology, well, you're all interested in that. All 3 of your projects, the homework project, the
I can trace.
Yeah, all of that. The trade, yes, indeed, and the digital passport. That's all to do with protecting technology. And there's
Jane, can I just interrupt you for a minute? Could you pay a little bit more attention in the sense that, because we are busy doing things, I mean, at which point do you think you realize that you need to do some protection? I find that very difficult.
Yeah, no, you should be aware of it all the time. This is why I'm giving these talks to the entrepreneurs who are basically just graduate students or people just out of various universities or art schools or whatever. Some have been around for a little longer, some have been around and never been to university, but generally speaking, when you're starting a business, you should have the legal protection in mind, and you should also be aware of the fact that your legal protection might overlap with somebody else's legal protection. So someone might think that some of the things that you're doing and using possibly belong to him or her, and you've got to have a strategy for dealing with that. So, as I say, those are the 3 things. And the last thing is, and this is going to apply to every business in this room, on this call, and every business in the UK, creativity, because you all have brochures, you all have manuals, you all have websites, you all have software, some of which you create yourself. All of that is what I call creativity, and that's protected either as a literary work, an artistic work, as a performance or something like that. So everything basically which gives, makes life worth living is an intellectual asset. Branding, design, technology and creativity. I think every business in this call have a brand. Probably the one thing which I shan't be spending too long is design, but even there might be something, particularly with some of the technical sides of your business. Technology, that's definitely something which you're all interested in. And as I say, creativity, websites, drawings, all that kind of thing, videos, yep, all protected or protectable. So without more ado, I'll just go into the examples of intellectual property rights. Well, patents for inventions, trademark registrations for distinctive signs. That's the logo, the name, the business name, or the product name. Now, you can have design registrations for appearance of products, but sometimes the shape or configuration of a product is, the way it works, is more important, and that there's some automatic protection which is available there. And then copyrights and rights and performances for arts and literature. And don't think arts and literature just mean fine arts. It can be as utilitarian as, say, a database or
database?
Yes, you can have that can be a literary work, yeah. It is. It's also the contents of a database are protected by another right called database right, but the design of the design of a database is a literary work, and you can protect it. Well, you get automatic protection, which I shall be dealing with in a few minutes. But yes, database, brochures, anything you send out, anything which is being said today, these slides. They're all literary or artistic works, and they're all protected by copyright. And you've got to be aware.
Yeah, I think I just interrupt you for a minute, just for the audience sake, in a sense that sometimes we also have a danger about if we don't protect it, we are being cut out, isn't it? If someone starts to claim the right. Do you know?
Yeah, well, you don't in this country. It's different in the United States and a few other places. There's no system of registration of copyright. If you,
all right, okay.
If you produce a drawing or a document, and it's in a fixed state, it's in permanent form, or in the case of a broadcast, it's a broadcast or whatever. But generally, if it's recorded and it's created by what's called a qualified person, which basically means a citizen of the UK or a citizen of a country with which we've got reciprocal rights, then copyright subsists automatically in that piece of work. And that means you can have the exclusive right to make or authorize the making of a copy, supply it to the public, translate it, and so on. It's not the same breadth of protection as you get with, say, a patent, which means that you can stop anybody from using the technology.
Sorry, Jane, you're saying that we don't need to register?
You don't need to register a copyright, a literary work or an artistic work or a film or anything like that to get copyright in it. It falls automatically in this country and in most other countries where we've got a reciprocal arrangement.
It's very interesting because I noticed that you don't do this, but some people, they are quite obsessed in the sense that every slide that they use, or even the lecture notes or whatever, they always put a C, you know, this copyright this person. So yes. What you're saying that even if you don't write that thing so obvious, there's a copyright issue.
Yeah, you don't need to do that.
Right.
At least not in this country. In the United States, it's a good idea to do so. But in this country, it subsists automatically from the second, and indeed all the countries which are party to the Berne Convention, which is really now most countries since 1980 when the United States joined, then that's been pretty well much the same sort of rule. Okay. So intellectual property are the laws which protect the intellectual assets. So just that's an important distinction to get clear. So basically, why do we have these laws? Well, essentially, there are two ways you can promote innovation. In the old socialist republics, like the Soviet Union and so on, one way to promote invention or innovation was basically to give an inventor certificate to the inventor and perhaps give him a few privileges, or if you wanted to promote skill, excellence in art, for example, you wanted to reward a ballerina, then the way of doing that was to give her slightly better terms, better living conditions, let her go on tour to foreign countries. Most people in the old Soviet days couldn't do that. That was one way, but it's very, very inefficient. And the other way is to leave it to the market. So if I write a novel about a wizard or something like that, a schoolboy wizard, the chances are that they're not going to be terribly interested in it, and it's going to die a death. If J.K. Rowling writes a book about a wizard called Harry Potter, well, it's going to be very popular. The market buys millions of copies of it, and that's the difference. And it's copyright which prevents other publishers in the UK or anywhere in the world from wholesale piracy of their books. So intellectual property are the laws that protect the assets, and they're the result of a bargain between the state and the creator. As I said, in the old Soviet Republic, you could give people better benefits, but there's no point in giving a monopoly because nobody's got a monopoly except the state. In a market economy such as ours, you say, right, well, we'll give you a monopoly of up to 20 years, so long as your invention is new, so long as your invention is inventive, so long as your invention doesn't fall within a number of excluded categories.
Yeah.
And you pay renewal fees. And don't forget, this is only going to apply to the territory for which it's granted. So if you get a British patent, it's for the UK.
As a practitioner, is there any kind of practical guide about how do you declare that it is a copy? In a sense that, you know, if I create another Wizard story, how can you claim that I'm copying J.K. Rowling?
Okay, well, yes, there is a rule of law. It's very much down to the judge or the other tribunal, which is...
so it's very subjective.
No, it isn't really that subjective. You've got to prove two things to set up what's called a presumption. The first is to show that the alleged copyist, alleged plagiarist, has had access to the original work. And then the other thing is you've got to show objective similarity to the work. It doesn't have to be a complete similarity. It might be just simply similarity in just one character or one scene. But if you can actually show that there's objective similarity, and this is not just simply likely to be...
I'm just very curious because I'm not sure if Rohan is really there or he's just leaving the account there. Say, for example, we have this design about how a market platform should be like. You know, it is a first design for the home worker in India.
Yeah.
So we design and talk about how they connect to each other. Do we get a copyright for that?
Yeah. You probably get many copyrights actually.
So if someone actually copy our idea and go ahead and do it, so we can actually sue them.
And I'll be talking about that later. Because that's because it's a great thing to be able to sue somebody.
So you're on, Jane.
Yeah.
we'll give you 5% for anything you can sue.
Yes, right. Well, I'll be talking about that. It's on paper, it's a beautiful intellectual property right, beautiful legal right. The only trouble is that you have to worry about courts and tribunals, and there are other schemes which we can think about, but that has been a great break on innovation in this country, because for various reasons it's the most expensive jurisdiction in effect to protect innovation and creativity, or we and countries which have got a similar legal system like Australia, like Singapore and like Canada, though not like the United States, because they've got a different rule.
I would like to maybe just move on a little bit faster in conscious of time. What is can we go straight to brand? What is the difference, can you see, as a brand versus IP? How do you recognize something as a brand?
Okay, all right, well, we'll go on to that then.
Yeah.
Right, well, basically, a brand is something which identifies a business or a product. It's usually a name. It can be a logo, but it can be anything. It can be a sound. It can be...
From what you've written, it means that we actually have to register for it.
Well, no, you don't have to register for it, because there are a number of alternatives, one of which I don't think will be might be interesting, might be of use to say your home workers, if, for example, they're working on a product which can be consumed, a food or something like that, which can be consumed anywhere in the world, like, for example, a pepper or a tea or something like that. That might be of some use to them. That's geographical indications. But for most practical purposes, most businesses can and should register their trade name and their logo, and sometimes also their product in all the markets in which they are going to be doing business. So trademark registration, basically, it means registering a name, registering a logo, registering a combination of name or logo, or any other identifier with the trademark registry, which is in Newport, for a specific range of goods or services, a specific class of goods and services. You don't necessarily get a monopoly of the English language or of a word in the English language. There are some cases where you have two trademarks, two well-known trademarks, but for different products. I mean, we've got Barclays for banking, but we also have Barclay Brothers for property development and investment. And in fact, also a chain of fast food sandwich bars in London. So, you know, you can have Barclay for the name, but three different companies own it for three different types of service or goods. But this is what you do. You apply to register for the, and it's a very, very cheap process. And I'll be taking you through that very quickly. But there's also a much older right called the right of passing off, which is basically the law that prevents a business misrepresenting itself as being part of, connected with, or having any other kind of association with another business. And that is a right which has existed really for about 400 or 500 years, and it's available for those who haven't actually got down to registering a trademark, and those which have but want to have a second attack at a particular infringer. Geographical indications are much newer. They only came in this country. There was a European right geographical indications regime which applied to this country until 11 o'clock on the last day of the year, but we now have a British one. Could be of use to say.
Can you give some example?
Yeah, Scotch whiskey, that kind of thing. Okay. I'll come back to this in a second. Okay. This is Hallan Mon sea salt. This is a type of sea salt which is refined from Anglesey, and they've got a geographical indication of that. Oh, come off. Just a second, it's going.
So I think the Scotch whiskey is a very good one because Scotch whiskey is very famous. So yes, are you saying that Scotch whiskey immediately should have a trademark, and then if somehow you sell another Scotch whiskey?
Yes, well, there's been 200 years of litigation over that. Scotch whiskey, Cornish pasties, the different types of wine which you can get from the main wine growing countries. Those are the things which are protected by.
I think I got the idea for this. Can you give an example for this right of passing off?
Okay.
You are saying that it's kind of by association or something. You claim you're trying to mislead someone that you are affiliated with someone else.
That's right. It can be a fairly barn door association. You can say, well, I've seen a pair of jeans with a red label, looks exactly like Levi's, only they're called Levites, L-E-V-I-T-E-S. I bought that in, or rather my late spouse bought a pair of jeans with that marking. That is obviously designed to get people thinking these are Levi jeans.
Oh, right, okay. Okay.
But it's often more sophisticated. The leading case on all this was really
I think I got you. Yeah, I know what you mean. Yeah, Audi has got lots of these. Yeah.
Yeah, exactly. There are all sorts of things like this, but they did
it on purpose. They put the real one and the fake one right next to each other. Yeah.
Well, yeah. Well, retailers have been doing that for years and years and years. There is a very, very fine line between what is going to lead the customer to think that the product is the equivalent of another product and leading them to think that it's the product.
I'm going to rush you a little bit. It's very interesting, but I really like to get to litigation. Can we jump to design?
Oh, well, we can do design now. Yeah,
Yep.
that's basically there are two types of intellectual assets which are protected. They're functional designs, which might be, for example, the clockwork of a watch or a circuit. That's protected in this country by a right known as unregistered design right, and it's in the shape and configuration. All you've got to prove is that it's original. That's to say, you don't have to be novel. That's a big difference between that and an invention. It can be. It's got it.
Do you have to register design?
No, you don't have to register a functional design. That's protected by something called unregistered design right in this country. But when we're talking about something which is appeals to the eye, for example, or to anything else, a touch or the ears or the nose or whatever, or something which appears to be aesthetics, as it were, then which might be a piece of furniture or it might be a garment.
Yeah.
For example, I've just been doing a case note on my blog about bodycon and bandage clothes. Those were items which you could register design right in. You don't necessarily have to. If you do, you have to. It's a 25-year protection. In the fashion industry,
Is this territorial? Like when you register in the UK, then you apply to the UK only?
Yeah, it is. Until last year, you could register for the whole of all 28 member states, or 27 member states plus us, I suppose, after the 31st of January. Now, you can still do that. You can still get a design registration for the whole of the EU, but it doesn't cover us.
Yeah, it sounds very tedious. Yeah, it sounds.
Yeah, well, it depends if you're, and this could well be again for your home workers, because if they are, for example, designing a piece of jewelry, a piece of clothing, a piece of.
No, I'm telling you something even better. I know Jason is online just now. Maybe he is. So we designed a blockchain structure. So we have a blockchain, and then we design it in such a manner that, you know, the police inspector is having this particular role, how the police inspector will appear in a blockchain. And then we have another one is like a healthcare worker, you know, and then the victim, how the victim will appear, you know, there's kind of this interaction with the blockchain. So in fact, I would claim that no one has come up with this idea before.
Well, it might be an invention.
Yeah, so I'm not sure whether what to call this. I mean, is this a
well,
design?
it might be an invention, and it might be worthwhile just going on to technology for that.
All right.
But just remember that there is protection for ornamental things which your home workers might well be creating.
All right, yeah.
And which their marketing company in the UK would possibly want to.
This is a very good point, actually, because one of the resistance of some of the home worker, the higher skill, those we call them actually artisan, even though they are still home workers. So the one thing they are very worried about coming to the platform is that they are very worried about their art being copied. You know, because they are open themselves, you know, advertising their work and their artwork. So yeah, I'm not, because will this work in India?
Yes,
it works in India.
They have a very India is one country which does have actually quite sophisticated intellectual property laws, and I do work very closely with a couple of Indian attorneys. One actually in this very field, which is trademark and design, yeah, they would look after these. They would prevent.
But is it very costly then if someone steals the design?
It is costly, I'm afraid, everywhere in the world.
Costly to chase,
but hang on a minute, you can get insurance. You can get insurance anywhere in the world. And there may be ways in which you can get schemes which cover a whole range of people in a particular industry. Maybe it's very, very small contributions from them towards a premium, but that might be, I mean, that's how actually collecting societies work. People who sing songs or they write the lyrics of a song or whatever, they're not basically able to take on the
you have an unregistered communities design in your slide. Yeah,
that's
that
right.
would be interesting. Yeah,
well, that anything which can be registered as design automatically gets up to 3 years protection, and that is extended to the UK because in the withdrawal agreement.
Could you move your slide? I think it is other people can't see it. Yeah.
Okay. Well, there's unregistered design right, which is, as I say,
one more, I think, one more.
Yep, unregistered community design, and now we have the equivalent. This is part of our agreement by which we left the European Union. We have something called supplementary unregistered design right, which basically is in the appearance of a particular product, and that's in addition to the unregistered design right, which we've always had in the UK, and in addition to registered design, you can still, if a product's going to be around for over 25 years, for up to 25 years, like for example a floss lamp, then you'd probably want to do that. And in something which is actually a work of art, you'd also get copyright protection, which in the case of an artistic work in Europe is the life of the artist plus 70 years. So it's a very, very long right indeed. In some countries it's even longer, it can be up to 100 years.
Does it mean that, let's say for example, these guys, do they have to write it in their inheritance and in their will to say that they're going to pass on this right to someone else?
Sometimes they do that, yes, you do.
Because like, I mean, if they don't do that, if they die, then the right probably die with them, isn't it?
No, it doesn't die with them. It goes to their executors or their administrators. But yes, you make a very good point. Okay. J.K. Rowling probably does have a literary executor, somebody who's responsible for the administration of her copyright.
Right. So because on this slide, what is the significance of the word community?
It basically means EU. Until
right, EU, huh? Yeah.
Yes, until the 31st of December, this right applied in the UK, and you could do two things. You could register a design, as you can register a design in the UK.
Fine. Actually, I love to push you to technology now because that is very interesting. That's very interesting for us. Yeah.
Right. Okay. Well, technology covers things like new products, processes.
You need to move one more page. Yeah.
Yeah. Okay. It covers all these things.
No. Yeah. Okay. Here. Yeah. That's great. Yeah,
now there are various ways, alternative ways of protecting the technology. Probably the most complete way is a patent, but that's also the most expensive way. One obvious way, if you're not actually putting something in the in the public domain, is to rely on trade secrecy. That's simply not tell anybody, and that's basically how you protect software. How Microsoft protects software. It basically keeps the secrets of its source code to itself.
Well, at the university, usually, you know, every time when we come to a meeting, you know, we'll issue non-disclosure. It's almost like the first steps. Yeah.
Yeah. Well, that's it. A trade secret is basically protected in this country by the law of confidence. And the law of confidence can be summarized, I think I might have a slide on it, is that it must be secret in its own, it must have some value in its own right, probably because it is secret. Secondly, it must have been disclosed in confidence or in circumstances giving rise to a confidence. And thirdly, its disclosure must be either damaging to the person who disclosed a trade secret or advantageous to the person who's ripping you off. Those three things. You don't have to register anything. That's common law, and it's been around for 400 years.
In your legal experience, let's say, for example, if you have a non-disclosure agreement, will people challenge to say that, yeah, we signed this for this particular discussion, but we did not cover this something else?
Well, this is a thing. Actually, what I was thinking of doing today for my blog article, because I try to get an article out more or less every day, or if I can't do it every few days, I was actually going to write a piece on protecting secrets. It's not what's in the agreement that's important. It's in how you police it. Now, many years ago, back in the 1980s, I was legal advisor for Visa International. It wasn't as big as it is now, but it did have offices in London and San Francisco and a few other places. And at that time, they were developing technologies which could read the card, send information back to the bank, and then give a very quick answer as to whether the card is all right or whether the bank balance can cover it or whatever. Before that, there was a credit limit of, say, £50 or $100, $100 US. And somebody came over, if somebody came over from, say, New York to Singapore, and they wanted to buy something which was, say, $150, say something in a market or whatever, they wanted to pay with their Visa card. It could take up to 24 hours for the bank for the retailer's bank in Singapore to send a text to the bank in the United States. Is this customer real? Is he okay? Now that obviously was a big restriction. So we're developing at that time various card readers, chip and pin. Now, all the time there was interplay between our techies and Ferrantes and goodness knows how many other people. I think Ferrantes, there were a lot of other companies around at that time who don't exist now, who were working with us. And rather than take the risk of passing our secrets and giving to somebody who's really say, well, this isn't a secret, this is something which has been around since Boyle's Law or whatever. I used to have a system by which before each meeting, I got the techies to decide what they were going to be talking about, and they would put this in a little box in a form. How long, whether they're going to, whether if information was going to be oral or whether it was going to be in a document. If it was going to be in a document, which document? What the person disclosing, who received a document, could do with it. That's to say, whether he could copy it or not, and who he could give it to, and when he was going to give it back. And it was usually this last thing.
It's
when
quite detailed, huh?
It is, but it doesn't take. But it's a lot better than just simply having to go and litigate everything and possibly losing a case. Because in my early days, I used to represent confidence, people who had been given information in confidence, and confiders, and it was very, very difficult to actually nail someone for infringing a trade. Well, it's now called infringement. In those days, it was simply a breach of confidence, because there was always going to be an argument. Well, yeah, it didn't really intend to cover this.
I just want to ask you, at the University of Manchester, the IP, the lawyer, whenever we ask, do this NDA, they always ask, like, what was the subject? Do you know what I mean? They seem to want to talk about a topic, to say that, what are you guys coming together? Are you going to talk about this blockchain, or are you going to talk about this particular digital passport? Yeah. It sounds as if that this NDA has got a topic. I can appreciate that, you can't cover all the conversation. Yeah. Well,
this is what we were doing. As I say, this is a dynamic technology. We couldn't trace a disclosure unless we could actually tie the piece of information to a particular non-disclosure.
So in your experience being a barrister, and then this kind of litigation, what is the chance of winning? I mean, or losing? Is it very difficult?
It really depends on the facts. So
case by case. Okay.
Case by case, yeah. But if there's time, I'll actually go into some of the difficulties with with enforcing a patent.
That's
so
fine. Yeah. So let us just quickly run through the list, and then we gone through the unregistered right before, the design right. What is this semiconductor topographies?
Right, okay, well, this is basically the shape and the form of the chip itself. It's it really only concerns, say, chip manufacturers.
It's really the hardware people. Okay, we can forget it.
It is a chip, and it's not even just the hardware. It's basically the design of a chip, the topography. Now, the thing about a chip is that it's at several levels. It's basically one bit's of wafers of silicon, which and each wafer has its own print.
I'm amazed whatever thing that you got yourself into, Jane. Database right. Can you give me maybe like one historical case that people sue about this database right? What are they suing for?
Okay, well, one very famous case, in fact, are the listings of the results of a sporting competition. For example, horses, a horse race. This is in the days basically when communications weren't that clear, but well, I think, yeah, it was simply the results of the horse race. So a bookie, I mean, the case came from the West Indies. A bookie in, I don't know, was in Trinidad, which is just off Guyana. Was taking bets on what was going on in Guyana, which was not very far away. Someone else was basically trying to get this information over.
Oh, this database, right? Do you have to register, or is it like a copyright?
No.
It's like copyright that it exists.
We've had it for 20 years. Another good example might be the telephone directory. That kind of thing, but it's basically anything. It doesn't even have to be electronic. It can be it's not so much.
This is going to be very important, because this, with the modern slavery, and then we're going to have lots and lots of databases.
Yeah, well, don't forget that you've got two types of intellectual property right in a database. First of all, there's a programmer's right in having created the architecture of a database. Then there's a user who's actually typing in the information. He or she is going through the database, pruning it, saying, oh, no, you don't want this information, this person's dead, or no, this is wrong, doesn't live at 48 Acacia Avenue, lives in 52.
So there's the coding part, and also there's the content part.
Yes, and it's the content part that lives up to 15 years, whereas a copyright will live to
this is amazing. Yeah.
The one thing to bear in mind is this is a right which was created by European Union law.
Oh, then you won't apply to India.
No. We've kept it on in this country, so it's still a UK right. We preserved it. We preserved most of these rights.
So all these not necessarily apply in India.
It doesn't necessarily entirely apply in India.
But what happened if you got this kind of supply chain network, in the sense that the brands is actually in the UK, whereas the home worker is in India?
Well, the home worker in India still has rights, and if he or
no, what I mean is like the database actually straddle cross-border to two countries.
Well, if there's been any kind of work done. Well, first of all, the design of the database, that will be copyright, and that will extend to India. The keying in of the information is what is database, right? It's basically the hard work, but not.
Anyway, we'll come to you when we have detail. What is the plant breeders?
Right. Okay. Well, that's in new varieties of plants, and this is important with climate change. It could be, for example, drought-resistant wheat strain, or the type of a grape or something like that, which is resistant to an insect or some other pest. It's basically a new variety of seed or plant. In many countries, these are protected, like the United States, these are protected by patents. But in this country and in many other countries, they're protected as a separate.
Do you need to apply for it?
Yes.
Okay.
You do. And this is the important thing. You don't apply to the patent office. You apply to the plant varieties office, which I think is now in Cambridge. It used to be in Kent.
I don't think it's going to happen to us.
It might, because there may be people who are working in the university developing plants.
I know, but maybe not to enduring that.
Well, it might be. They might be coming to you. You might be going to them and saying, "Look, we've got these home workers who can't grow cotton because in Rajasthan because it's climate change, but we do know that you've got this cotton strain or whatever." The university might well want to license it out. And one point about licensing is that it does protect the quality of the goods. It can be in the interests of the licensee as well as the licensor. I'm going to talk a little bit. Trade secrecy.
I think we gone through that. Patent. We gone through that.
All to say is,
I think the copyright, we've been through that as well. How about obtaining legal protection?
Okay, right. Well, remember that there are basically.
Can you move your slide further?
Yep, I can.
Here, yeah.
Yes. Basically, registered designs, trademarks, and patents have to be registered. And also plant varieties. As I say, that's something which you can put to one side at the moment. There's a separate ministry which looks after them. But important thing to remember is that registered rights are granted for one particular country only. So if you want
I find this very frustrating, and to some extent I really can't be bothered, because a lot of our work is very international. And then any paper publication, any communication of this kind, or even the supply chain, is going to be international. It's kind of very crazy to think that it only protect one leg when you are in the UK.
Yeah, exactly. And what you would probably want to do would be to protect your asset, one, in your market, and two, in the in the producer's country, and three, in a potential competitor's country. That's basic strategy. Let me just give you a very, very useful guide which I give to my clients, startups and others, when thinking about setting up a business. This is basic strategy. I think Michael might have gone into a bit more detail, but it's what I tell people. I think it's all you need to know at this point. The first thing you want to consider is how long the development of the asset is going to take, and what sort of period you're thinking about. So first of all, you choose the period, which is usually like the period of your business plan. You then, stage two, identify what your income streams are going to be. Three, what are the threats to the income streams? Now, these may well be, you heard in the last speaker talk about, Chris was talking about grants and fees for services and so on. Well, that's sort of thing you need to think about too. Three, you have to think about the threats. And most
threat meaning competitors or something?
Well, it can be anything. Which intellectual property infringement is probably not going to be the most significant one. It will be in things like telecoms, it will be in things like possibly in fashion, and it will be in such things as drugs and that kind of stuff, pharmaceuticals, but it won't necessarily be in every kind. Sometimes in, say, the fashion industry, it may be just that somebody's gone out of style, or in the mobile phones or technology, there's a new technology. But for some people, that having the inventive edge or the creative edge is going to be what you need to protect, and that's where intellectual property comes in. And remember, there are often more than one way of protecting an intellectual asset. It might be by a patent, it might be by trade secrecy, it might be by unregistered design right, it might be by something else. A very, very big lacuna you should be aware of is that our law, based on the European Patent Convention, excludes from patentability computer programs. But the way around that is to invent, say, something which uses...
Sorry, what did you say about computer program?
Computer software is specifically excluded from patentability as such, and the words as such are important, because the way around it is to go to the patent office, say, well, I haven't really got a bit of software which I'm trying to patent. What I've got actually is a new flight simulator or a new tool, a new machine tool, digital tool. It may be exactly like every other digital tool, and the only difference may be in the program. But if that program makes a digital tool operate in a different way, or a flight simulator operate in a different way, you might have a patentable invention, and that might be relevant to your blockchain.
I think you were there when INGI was presenting the identityless contact track and trace.
Yeah. I was. I've been here for all the...
Yes, I noticed you were there. So is that patentable?
Could be. What you've got to do in order to find that out is, one, get a search of everything that's been registered as far as we're aware. Now, one of the problems we've got in this country is that whereas 20 years ago, most of the world's technical literature was in English or in another European language, which most of us, you know, when I was in high school, you had to do German if you wanted to do physics or chemistry or economics or theology or history. Now, to be quite honest, it wouldn't really get you very far, because the world which creates most, of the world's new technical literature will be doing it in a North Asian language. China makes 1.4 million patent applications every year. To the European Patent Office's 130,000. And that's all the countries. Or the UK Patent Office's 20,000 applications. Most of the world...
Patent, I don't quite like patent. Patent in the sense that it's always very jurisdiction, very kind of sovereign based. Is there any other way of protecting without going into patent?
Yes, I mentioned it before. The best way is simply, if you can, to rely on trade secrecy, not actually...
So, for example, the thing that INGI has presented, and then we put it in open source. Is there any way that someone else go and patent it, and then we end up having to pay?
Well, that's a difficulty, or the patent probably wouldn't be valid, but you would have to go for a rigmarole in the patent office or a foreign patent office to say, well, hang on, this chap in Outer Mongolia has has applied for a patent for this invention, but I do know that this has been invented.
I give you another example, which is much closer to home. Yeah, so we actually been sued by Ticket to Go that we use QR code.
Yeah, I know about that.
We infringe their copyright.
Well, that's what they say.
Infringe their patent. However, if you look at Wikipedia, for example, the QR code was actually invented by some Japanese long time ago.
Yeah, that's what I'm
saying. Can we claim that, you know, but these Japanese, they actually not patent it. They just let everybody use it.
Right. Well, I mean, the reason why I referred you to a patent attorney when you first asked me about this in general chat a few months ago was because it didn't seem to me to be very likely to be a valid patent. I haven't seen that patent. I don't know what they're actually claiming. But
they just say that you're using a QR code. You are infringing our IP right. patents.
Yeah, they may not be claiming the any monopoly in the QR rights. Don't think they can. What they might be claiming is in the way you're using it. That is something which you've got to think about. But the usual challenge of that is done where a patent attorney says, right, well, I've read all this. What exactly are you claiming? And the other side then says, well, we're claiming this, that, and the other thing. And he says, well, you can't, because A, it's already known. And if it's already known or it's already obvious, then the patent is invalid. And to give you an example, over 50% of all patent infringement claims, including those I've been involved in, the patentee has had a bit of a patent. I usually represent people who are accused of infringing rather than people accused of, rather than people who are enforcing a patent. And I've nearly always been able to knock out a bit of the relevant bit of the patent claim basis. So up to 55% of the patent claims in this country don't actually make it. They're challenged in the court. And the reason for that is that the poor old examiner, who's not paid a brilliant amount, he might even be working as a homework himself for the patent office, he's only given so much time and so many resources. The inventor or the inventor's patent attorney comes along and says, will you go along and examine this and see whether we're entitled to an invention? And he'll look at a few databases. He doesn't, the chances are he won't understand Mandarin, Japanese or Korean, so he won't be able to do, he'd have to rely on machine.
So you are saying that you winning the cases in most of the time is because of the incompetence of the patent office. So you are trying to overturn their registration.
Well, it's not so much the incompetence of a patent office. It's down to the fact that, first of all, there's a duty on the inventor to make full and frank disclosure, not to claim things which he's not entitled to, and so on. But we're living in a different world. I've got a little job which gets me to Geneva every year. I decide domain name disputes. That's where you get somebody who's got a trademark and someone else who's registered a domain name, which is very similar to his trademark. And every so often I have to go to Geneva. Every year I have to go to Geneva for continuing professional development training. And I remember in 2003, the person who was until recently the head of the World Intellectual Property Office, which is the UN agency for intellectual property, said, ladies and gentlemen, by the end of this decade, most of the world's technical literature will be in a North Asian language, Mandarin, Korean, or Japanese. 2004, 1 year later, he said, ladies and gentlemen, you know what I was saying, that by the end of this decade, most of the world's new technical literature will be in a North Asian language. It has already happened. And 2 years ago, China overtook the United States as being the main exporter of technology from, for applications for international patents. There's an agreement called the Patent Cooperation Treaty. It doesn't mean you can go along and get a world patent.
So in fact, I can see that, and during that, in fact, I would imagine that quite a significant amount of time, if it go anywhere, is going to go into a lot of these litigation cases, I think.
Yeah, I better just say a little bit about litigation, because I've only got a few minutes left.
Yeah.
Well, one day, I mean, you'll get getting these slides. So first of all, I'll give you some costs of prosecution. If you want a patent for the UK alone, the going rate is
you need to go a bit further down.
Yeah, I do, but you do need to know about this.
No, I mean, your slide is not synchronized. I think you need to move one slide down.
Okay. Well, that's enforcement. Can I just go
one slide up? Yeah, there you go. Yeah.
Yeah. If you want a patent for the main European countries, it will cost you about £30,000. If you want one for the main countries in the world,
yeah. I think we are not likely to be prosecuted. I think we'll be more likely to be defending.
This isn't crime.
No, defending.
No, it means applying for a patent or a trademark or a registered design. So if you want a patent For the
Yeah.
UK, the least it'll be £5,000. And as the UK is a very tiny country, there are only 70 million people,
I know,
8 million people
I
in
know.
us. And although they say we're the sixth largest economy in the world, or the seventh largest economy in the world, that's still not very big when you compare us to China.
I know. I think
United
this is
States, so
not
on.
something. This is not
You would
something.
really want number
Yeah.
3, and that's what the big telephone companies, telecom manufacturers, Huawei and so on are after.
Right. What
For
about the
trademark,
typical defending cost?
okay, litigation, right? This will shock you, I'm afraid. Basically, you've got to go to court, and if you're trying to enforce a patent, or for that matter, a trademark in the High Court, a patents court, where I usually go to, the claims can be unlimited, but the costs which each party is likely to pay is likely to have to pay for its own services can be anything up to $1 million. And although the successful party at the end of the day can get a contribution of its costs back from the other side, it's not going to be all those costs.
So these are really legal fee. What I'm trying to say is, let's say hypothetically, this ticket to office, they send us this legal letter to say that we are using the QR code and then we are infringing. If we ignore that letter and then we continue to use the QR code,
you could get yourself in litigation.
So apart from the court expenses, how much can they sue us?
Well, they could sue you for whatever they feel like, what they could get out of it. As I said, it doesn't sound to me as though it's
if we, let's say, for example, does it depend on my revenue?
It depends on the sales of the particular product. Yes, that is a relevant consideration.
So if we don't make, so in a sense that the liability is capped by my revenue, right?
Well, yeah, but there's another way of looking at it, and that is, it may be that you, as a defendant, haven't made any money out of it, although that could be a relevant consideration. It may be that they claim that they've suffered something as a result of it. It may be the claim that there's been a
damages.
Well, yeah, yes. In any intellectual property claim and a few other types of claims, a claimant, an injured party, has a choice between claiming compensation for the damage he or she has suffered, or claiming the disgorging of the benefits, of profits, which the wrongdoer has acquired. And the injured party always gets a choice. So after cases usually are in two sides, but to proceed in 2 stages. The first is a decision over liability, whether you've actually infringed or not, whether the patent is valid or not, etc. And those can be very expensive if they're in the big firm of London solicitors called Taylor Wessing compared the cost of litigation in all of European countries. UK came top, or rather England came top.
To some extent, it's a hard reality, isn't it? So does it mean that we can't use our digital passport then?
It means there's a risk, but you can mitigate that risk, and I'll be talking about this in just 2 seconds. The first thing, however, is that that's a High Court. There is actually a court for smaller claims, smaller companies. These cover all types of intellectual property rights, including patents, where the claims up to £500,000, but costs are limited. You can't get more from the other side, the losing party, than £50,000. And that actually helps medium-sized companies. And then now, and this would help some of the companies in your consortium, there's a small claims track where the most that you put at risk is a few £100, the issue fee, and that covers everything except patents and registered designs and semiconductor topographies and plant varieties. So that is something which is for small businesses, the last thing. And there are alternatives. The IP office in this country has a mediation service. their domain name dispute resolution policies for domain name disputes. You don't have to go to the High Court and risk £1 million. You can pay the WIPO $1,500, and they'll get me to do a case, to decide, me or about 800 other people, to decide whether or not the domain name's been pirated, and I get about $1,000 out of that, and the WIPO gets the other $500. And then there are such things as examiners' opinions on patent disputes. You can, I mean, this, I don't want to second guess Michael's advice on this, but if there really is a question that he thinks that there may be an infringement, you could go and get an examiner.
There's something that I learned that is very useful through this process. You actually have the right, you know, if someone is suing you like this, if someone is laying this claim, you actually have a right to ask them for the list of licensee they have. And then in fact, you also have a right to ask them how much the licensees are paying them.
Oh, you have all this, yeah. You're entitled to full information about this.
So to be honest with you, I think Jason is still on. So because the digital passport is a very, very big business, it's now increasingly really big, getting bigger because of COVID. So we are just literally just waiting for the big guys and see what is their move. Do you know what I mean? So we're just waiting to see whether the big guys like Evening, you know, what is the other name?
Yeah, I know.
Trinsic, Evening, you know, even like the Singapore SingPass also use a QR code. We're just waiting to see whether these famous people, you know, famous organization appear in their licensee list.
Yeah, there are all sorts of trying-ons, but there are things you can do about it. One thing which is available to small businesses, and something which you can think about, is to get before the event insurance. After the event insurance, I'm afraid, is
no.
But before the event insurance is sensible. Then there's such a thing as third-party litigation funding. You can get a third-party litigator funder. It's a financial service which is growing in really most countries in the world.
Is there any way that we can find out like pending cases, like whether these guys and Evening or, you know, Trinsic has got any pending cases that they are suing each other? Well, where do we find those? Yeah.
Well,
are they secret?
No. Every time you're going to put a court document in the public domain,
so you should know that. Yeah.
I mean, there are some publications, trade associations, and so on, which say Alphabet is suing Facebook for this, that, and the other thing.
Okay. Yeah.
Then for the United States, there is such a thing as no win, no fee, which doesn't really work here because of our cost structure. But these are various things that you can think about. And this is where you can get more information. Some of the slides that I've got have films which come from the Intellectual Property Office. Go and have a look at those. They only take about 2 or 3 minutes each. Okay. The United Nations Agency for Intellectual Property has masses of useful information, including 1 or 2 films, one of which I've used. That's the World Intellectual Property Organization. It's since 1970, it's been a UN agency, but it's existed for a lot longer than that. The European Patent Office, this is not a UN agency. It's basically an intergovernmental office which grants patents for up to 30, I think it's up to 42 countries. 1 or 2 of which, Cambodia, Morocco, and I think a few other countries, are even outside Europe. Basically, you could apply for a UK patent by going to Newport, or you can apply for a European patent, which would include the UK, by going to the European Patent Office, which is in Munich. And if you say you've got an invention which is going to be for which you want protection, say France, Germany, UK, Italy, Netherlands, Switzerland,
but as I say,
that makes money.
In the next 5 years, I see more we are on the defending side rather than on the prosecuting side.
Yeah, well,
So anyway, we kind of seriously overrun the lunchtime.
okay, right. Well, these are the other things you would. Just let me just finish. The British Library Business and IP Centre, they have actually here in Manchester a branch, and that's at Central Library. Then there's my stuff here, which is NIPC Law. I showed you how the blog works when we talked about it informally a few months ago.
Yeah.
And this was originally for NIPC Wales, but I've actually got a better one for the Northwest called IP Northwest. But you can get access to it through the.
You say that you run the innovator clubs. Is it?
Yeah.
And then you say that you halted it because of COVID. I mean, whenever you renew.
No, I do it by Zoom.
All right.
Yeah.
Do give me the link. Do you have the link?
Yeah, I do. This is the Liverpool Business and IP Centre, but there's one in Manchester just like that. I mentioned Liverpool because that's closer to Anglesey.
No, your innovator club.
Yeah, and then of course here are the people who are helping the
Science Power. Yeah.
Yes, well, they're all helpful. They were all used. You could all use these. These are all useful people.
They're not free of charge, right? Are they free of charge?
They do what I do, which is basically do talks. They'll also do clinics up to a point. Through, as I say, like the one I do in Barnsley and the one I do here. And these, as I say, now we've got a pandemic. We'll do the free 30 minutes or so, pro bono 30 minutes advice or 30 minutes other service. I don't do more than 30 minutes, I'm afraid. You can't get me to go along and represent you in a whole case, but I can certainly put you in touch with other people.
Yeah.
I put down there Sean Thomas as a patent attorney. He's in partnership with Michael Harrison. So all these people are relevant to you. And this is basically what I would have said. And this is where I am. And if anybody wants a 30 minutes, because the pandemic is such, I don't have to, I can't go to Barnsley and I can't go to Anglesey to see my clients. I do it all over the phone or by Zoom. If you want to consult me for a clinic, get in touch with me through my email and I'll talk to any of your members. Okay, you can give me a call. That's my office number. It'll always be put through. I once got a call when I was on holiday in New Zealand. It was the middle of a night, but the call was made from a solicitor in Reading to London. It was 12 o'clock midday in London, 12 o'clock in the morning in New Zealand. But I took the call and I gave the advice over the phone. So.
Thank you very much, Jane. It's been really so much information in there. Yeah, thank you. Thank you. So it's lunchtime, everyone.
Right. Okay.
So I'm just going to stop the recording.